Pronouncement of judgment of item number 1.
Left to read everything. For the foregoing reasons, this court is unable to accept the challenge raised by the petitioners to the entirety of sections 1 and 2 of section 6 of Arunachal Pradesh Urban Local Bodies Disqualification on the grounds of Defection Act 2014. This court is unable to hold that the legislature was constitutionally precluded from providing an appellate remedy against a decision rendered by the State Election Commissioner in exercise of the statutory jurisdiction conferred by the Act of 2014. The said jurisdiction does not merely by reason of being entrusted to the State Election Commissioner become identical with the constitutional functions assigned to the State Election Commission under Article 243K and 243J of the Constitution of India. However, insofar as the proviso to Section 6(1) is concerned, the position has to be examined separately. The provision, to the extent it provides for an appeal before the minister in charge of the urban local bodies, where the chief secretary also functions as the State Election Commissioner, creates an appellate mechanism before a member of the political executive in matters concerning the electoral disqualification. Such an arrangement does not sufficiently safeguard the requirement of an independent and impartial adjudicatory forum, and to that limited extent cannot be sustained. Accordingly, the proviso to Section 6(1) of the Arunachal Pradesh Urban Local Bodies Disqualification on the grounds of Defection Act 2014, to the extent it provides that appeals shall lie before the minister in charge of urban local bodies in the state is hereby declared unconstitutional and struck down. The remaining portion of Section 1 and Section 2 of the Arunachal Pradesh Local Bodies Act 2014 are upheld. The appellate mechanism provided therein shall continue to operate in accordance with the law, subject to the observation made herein above. It is made clear that this court has not examined the legality, correctness, or merits of the proceedings arising out of Appeal number 6(1) of 2024 or the notice dated 11/12/2024 issued by the Chief Secretary, Government of Arunachal Pradesh, as the petitioners have consciously chosen not to challenge the said proceedings and have confined their challenge only to the constitutional validity of subsections 1 and 2 of the Section 6 of the Act of 2014. Consequently, writ petition stands partly allowed to the extent indicated herein above. The challenge to Section 6(1) and Section 2 of the Act of 2014 is rejected, except to the limited extent of the proviso to Section 6(1), which provides for an appeal before the minister in charge of urban local bodies. The parties shall bear their to bear their cost.
Lordship, may I mention item number 4? Lordship, here the service is still awaited. May I be allowed to take press stress?
Okay. Office note indicates that service report in respect of
Private
respondent is still awaited. This stuff, accordingly, and as prayed for by Mr. R. Koilan, counsel for the appellant, a week's time is granted to take press steps for service of notice upon respondent, for respondent.
Yes.
Sole respondent.
Sorry.
list the matter after 4 weeks.
My place, Lordship.
Yes.
Lordship, I beg to mention item number 11. Here, Lordship, I have to file additional affidavit
Hmm.
by bringing the land and
On the prayer of Mr. K. Learned Counsel for the petitioner. Let this matter be listed after 3 weeks so as to enable him to file requisite affidavit, additional affidavit.
Deeply obliged.
My Lordship, I beg to mention item number 20. The conducting counsel is authorization. Matter may be adjourned for today.
What's there? Nothing remains. You argue the matter, we'll hear you.
Your Honor, for today only, matter may be adjourned.
See, you want no objection to have a art cutting passing through the forest land.
Yes.
How it can be permitted? And your NOC is under process for cancellation. Very your senior.
He's out of the station. Consent also has
Ask
been
him
paid.
to appear through BC.
He's in zero court. He's in zero court. He's in zero court, Your Honor. So it is.
You argue the matter. Do you have the brief? There's nothing. What is the ground?
Yes. Only for today, matter may be.
What to do? Okay.
Next week, Tuesday, on the prayer of MS
M. Jarang.
N. Jaram, Learned Counsel appearing on
For-
behalf of Mr. Arsona, Learned Counsel for the Learned Counsel for appellant. On the ground that Mr. Sonar has some personal difficulty today. Let this matter be listed on next Tuesday,
Okay.
25.
25,
Okay. Much obliged.
as a fixed matter.
Okay.
My Lordship, I beg to mention item number 21 with
21.
with the consent of others party. My senior is due to personal difficulty. He could not appear.
Where he is?
He is on medical now.
Mr.
BCO on behalf of
Learned Counsel for the Learned Counsel appearing on Ms. T. Tapak, Learned Counsel evidence submits that Mr. Tapak has some personal is indisposed today. Therefore, press for listing of the matter after
Lordship 2 weeks.
10 weeks.
2 weeks.
2 weeks, huh? We are not being objected to by Learned Counsel for the respondent that this matter will be listed after 2 weeks. Huh? Hurry up, please. Come first.
Lordship, I beg to mention item number 22, Lordship.
Yes.
We have also taken.
All adjourned. All matters are adjourned. We'll raise now.
Lordship, in 22, I am for the petitioner, my lord.
Yes.
My lord, can it be on
What-
25th of this month, my lord?
Huh?
25th of this month, my lord. 25th of August.
No.
25th
No,
August.
if you are
Lordship, I have another matter in answer on 26, Lordship. Kindly fix it on 25, my
on
lord.
the prayer of Mr.
Ela, Lordship.
Waigao, Lordship.
Why?
Waigao.
Waigao Learned Counsel appearing on behalf of Miss Learned DSGI, Learned Counsel for the respondents, and prayer not being objected to by Learned Counsel for the petitioner, Mr. Elal.
Ela, Lordship.
Let this matter be listed after.
On 25th
3
of this, no, Lordship, it is 1989 matter, my lord. It was dismissed on 1989, Lordship. 3 rounds of
But
litigation is already.
Rate petition is 2025.
Writ petition is 2025, but 3 rounds of litigation were there.
Sir,
25th of
it cannot be. It cannot be all the time for the convenience of the lawyer.
Lordship. I leave it to
After
Lordship
2 weeks.
discretion.
2 weeks, 2 weeks. Yes.
After,
Your Lordships, I beg to mention item number 19 for adjournment. Learned Senior Counsel's out of station.
Let's find out.
Finish.
Even if fixed on
Appeal.
On the prayer of Mr. M. Pertin, Learned Counsel for the appellant. Let this matter be listed after 3 weeks.
my lord, a fixed date may be given, my lord. If
My lord, after 3 weeks, this is the fixed date, but today they didn't come prepare. I come prepare with this case. So let it be after 3 weeks, man.
3 weeks, give the fixed date.
Yes.
Both side,
Yes, my lord.
both they pray.
Obliged, my lord.
After 3 weeks,
Fixed
you
date.
give the fixed date.
15 September, 15 September.
Man is in jail.
Yes,
Appellant is in jail.
Jail appeal, my lord.
So why 3 weeks?
Today, in fact, we came for disposal of this matter
Okay,
only.
Mr. The learned additional PP is present.
Obliged, my lord.
Lordship, I beg to mention one the unlisted I
For what?
it's urgent matter is for the dispense
Division bench.
yes, my lord.
In item number 3,
Hmm.
2 officers, the chief engineer and the executive engineers were personally called to appear. The chief engineer is out of station. That's why
It's in
this
Delhi
I-
now.
for-
This matter may be take up together with the item number 3.
I-
It's unlisted item.
there is a
Yes.
direction for personal appearance of the chief engineer. That's why.
Yes.
Much obliged.
Item number 2.
My lord, item number 2, before my lord takes up, may I pray that this matter may not be live streamed, my lord.
Okay.
If the live streaming can be stopped for a while, my lord, while taking up this matter.
Why?
My lord, I want to make certain submissions. Portal, some patching was done. That is the only thing that was done. There was some work in A sector side, I am told, that is now in fact because of the rain that is gone.
Let us hear which chief engineer is there?
My lord, today's IA, what has been mentioned, my lord, chief
See,
engineer,
we're not here to, trouble them. We're here for the public interest. Call the executive engineer there. Yes,
executive and the SC is there.
please come forward. Tell us. Yes.
Yes, sir. So, I have annexed the action plan for maintenance. It's annexure 4,
Which one?
annexure 4,
11.8.
11.8,
11.8 status report.
17.8.
17.
May I just point out, Manuel, before the officer addresses the lordship.
Yes.
The direction in 8.4, was giving other directions, the direction was that the road should be made motorable, the maintenance should be done. It is in that respect, this honorable court, not on my prayer, on his own volition, wanted the personal presence of the chief engineer and executive engineer. Yes.
1040. Sir, I have.
Where is that?
Action plan for.
Did status
Yesterday, no, my lord, yesterday we had filed an additional affidavit.
additional?
Additional affidavit,
Please.
starting from page 1010.
Probable which not there.
When is this file? 17 August. 14?
No.
17 August. In the affidavit. Affidavits, volume 3.
Yes.
Interesting. Okay, okay, okay. It's fine.
Is it? 76.
Chisito. Oh, email. Yes, Yes. Yes, yes. Yes. Yeah. Six hours. When this last order was passed? When our last order was there? 13.8. Yes. STMC person. Sir. Itanaga Bandadeva package B NS 4 and 5 was permitted on 29th April 2026. Right. Thereafter, department had engaged contractors to carry out the emergency repair maintenance. So in the meanwhile, we were pursuing with the MOTs for sanction of short-term maintenance contract. That provisions includes potholes repairs and page repairs. So the contractors the department had engaged, we had carried out the maintenance and we have been carrying out also. That has been annexed in this Annex 4 in this one, page number 1040. So thereafter, after the approval of the STMC short-term maintenance contract, we had floated the tender, and subsequently we we identified a contractor, STMC contractor. The agreement was signed on August 5th. Sir.
6th or 5th?
5th. And date of start was marked as 8th August. But then before that, the STMC contractor had already mobilized the machineries and started the emergency works, purely on the condition that the road condition is very pitiable, and to give out maximum convenience to the road users. They had already taken up the emergency maintenance operations that has been provided, that has been recorded in Annex 4 and page number 1040, my lord. Likewise, the contractor has been given a detailed identification location-wise details of the potholes wherever work is required. The contractor has been instructed to give a detailed work program so as to carry out the repair maintenance. Sir.
Are they really working on the ground?
Yes. It's on the ground, sir.
When was the agreement?
Agreement
for maintenance?
Has been drawn on 5th August.
Where do you get it?
5th August, it is
10?
This one. Last. Last this one, this next episode.
Then let us see, since their agreement has been signed on 5th August
Well,
only, and if they are,
I never
saying
made
that,
any
yes.
submission for regarding
1024.
this maintenance.
Hmm.
My concern is that there's already a direction that the meeting be held between the state officials and the MRTS to finalize the fresh tender. That is another thing. I'm worried now.
No,
September,
they have said,
we are most probably losing this working year. Apparently,
they
this is
said,
gone.
they have said, they have
As far as the maintenance is
submitted,
concerned,
modified that thing.
I have understood. It will take some time to come back.
Mhm.
Then they will float tender. It appears to me apparently the working season will go.
Hmm.
As far as this maintenance is concerned, I think it's a cruel joke on the public of this town. 1040. If this is the maintenance they are talking about, it's a 5 crore waste of public money down the drain, nothing more. Is this the maintenance they are talking about? It's unbelievable.
1040.
If this was to be done, what was the necessity of floating a 5 crore tender? We could have been like what it was. I don't even go through their additional affidavits anymore. I just saw it. 1040. The near Newry Market, Papunala, Moti Mahal, Papunala, Pachin entry, Sohum entry. I always come through the Sohum entry road. If this is the maintenance they are talking about, I don't believe it. It's a cruel joke. I didn't knew that they had maintained that road. My lord comes from Itanagar every day.
When they have started the work?
No, they should have done what I have understood now. They have filled up some mud.
You have done or is it
Done.
to be done?
Done.
I mean, completed.
It has been in the action
1040.
104. It has been detailed out. Emergency repairs already done, already completed the works, and proposed repairs. This
That's
is
why
the
I was
action
pointing out.
classification.
Your lordship, Justice Habung, may kindly have a look at page 1041. From 1040 onwards, your lordship comes that way. The maintenance that have already been carried out. Papunala Market, Papunala, then their Moti Mahal, your lordship comes that way. Pachin entry, Sohum Barapani Bridge, that the road I come every day. If that is the maintenance they are talking about, which has purportedly been done, it's absolutely unbelievable.
See, serial number 4. This is emergency
Unbelievable.
repairs taken up. It has not been completed, and they have just started. This will be completed
It will be done.
with the bitumen and all those
in the remarks column, you see 1040,
Huh.
I classified non-STMC and
What-
STMC portions.
What does it
What is
mean?
NTST?
STMC are portions, those portions that have been already completed between.
Yes.
So
Then my lord, you kindly come.
What is
for the section.
STMC?
Sohum Barapati Bridge is completed.
Short-term maintenance.
maintenance contract.
So these are not to be, they would not be bitumen, laying of
No.
bitumen all.
It will be done by STMC contractor.
Hmm?
STMC, the mass column, whichever it has been entered as STMC, it will be done by the STMC contractor.
Huh.
And those incomplete stretches has been taken up under non-STMC. That is been funded by state government. That's it. So more provisions me to take up the STMC, identifying the potholes for the completed stretches. So if for the incomplete one, state fund has funded it. So by using the state fund, I have completed the non-STMC portions. STMC portions remains. For that, contractor has already, has entered in the agreement.
See, for example, serial number 4,
For
1040. So it is, it's emergency repairs taken up.
yes,
The next column already completed. It's completed.
yes, it has been done.
Emergency first, you take up emergency and then you laid, I mean,
ये complete हो गया.
what do you call it?
Papunala one, no?
अपना लगा ये complete हो गया.
Oh, no, it has to be done. It's written there STMC.
Huh.
So in the proposed repairs, I have written portal repairs. That has to be taken up.
See, just 1040, I'll just give an example. When foreign thing stands, serial number 4.
For
First,
Serial
emergency
number-
repairs taken up,
uh,
right? So machines are there. And then next column, it is action plan already completed. It's completed or what?
yes, serial number 4, whatever I have written that emergency repairs taken up, prior. See,
The last one, the last picture.
Month of May, June, July, we have been taking up the temporary repair maintenance. So I fixed the pictures, whatever pictures, to just to, so that we have been maintaining taking up the emergency. Now it has been DBM. DBM construction has work is completed now.
See, it cannot be gone.
Like
It's- we understand because of the weather condition and all that, one could understand, but then it cannot be gone. See, for maintenance, for also maintenance, you have to complete.
Well, 1 minute,
You have to complete the work,
right. So,
all right?
sir,
And potholes and everything, it can be done later. This thing. For maintenance, it means when you have already plotted tender for 5 crores, it has to be complete. Maintenance has to be complete.
it will be done, sir. It will be done. So 5th August only we have drawn the agreement. Sir. And
When is the completion date? Is there any completion date?
1 year, within 12 months, they have to complete all the maintenance period.
For
Package-
what is the stage?
in the package B and
Papunala to Nirjuli.
right from Papunal, no, from package A to package B. Those are inclusive in this this SMC package.
It's up to where?
From this Chananagar bridge to Nirjuli.
Chandanagar to Nirjuli.
Yeah, package A and package B. They have taken up under this STMC ministry. And that's why, sir, I wanted to bring on record this right from the June, whatever, which one day we had the rainfall law I've mentioned, because we were supposed to carry out the bituminous repair works, but because there was quite of rain, so we couldn't take up the permanent works. So we, out of the 78 days, 30 days was the net effective days.
See, I was not getting the thing. This carpeting or what is called? Carpeting,
Yeah,
laying down the bitumen, all this thing.
DBM. So for non
DBM.
STMC portion, they
You
are
tell us in
constantly
full
DBM.
this thing. DBM, we don't know. SMTC, we don't understand.
That's why, sir, I come
Hmm.
explain whatever I could. So for incompleted stretches, so we will be taking up the DBM, I mean, dense bituminous macadam payments. For the STMC portions, we'll only take up the pothole and the patch repairs.
So this, again, come to serial number 4.
Yes, yes.
This first column, emergency repair, this will be, this will be carpet.
No, it has been already done, the already completed one. Yes, I wanted to show,
Carpeting is done.
it has been already done. It's already completed that column.
And serial number 3, it has not been done.
It has been not done. It has been taken up in the potholes. There's some proposed repairs I've taken up under STMC.
Okay.
Simple one. Very
This
clear.
completed in the sense by STMC or what? STMC is what?
Short-term maintenance contract.
This present one.
Yeah, present one.
Short-term period of
12 months.
12 months.
12 months.
So these, what you have said, it has been completed, say, period number 1.
Period number one.
Making market
This
is executive completed. That means it will last for 1 year.
It is under non-STMC. Sir.
Not. So completed,
Okay.
Explain.
completed means
All are non-empties.
from your
Can
side.
explain, but we also write on this road.
1 year.
No, 1 year, some maintenance obligations are there.
Maintenance
Even-
obligation,
even
that
they
means
have
they'll
done-
come back
they-
again.
Yeah, even if the portal develop them, they have to maintain. Obligations are there.
Okay.
Are you seriously have the maintenance all over from the package, all the package 1 and B?
So package-
Will it be completed by this contract?
It has to be done since
It has to be done is something, but
The
it
contract
has to be, you have to ensure.
the contract has been signed. So when we have entered the contract, the under contract provisions and obligations they have to do. Otherwise, there's a penalty, and whatever course of actions the contract that derives will take.
After this maintenance, whether maintenance work has been done, as you said, it is completed, whether the engineer has checked the quality, has it been done as per the specification?
It has been done as per the maintenance standards. It has been done.
Okay,
So there's an obligation.
so it is expected to last for 1 year.
Even though it doesn't, they have the maintenance obligations
Okay, so,
at no other extra cost. No extra cost.
okay. So where the public should complain?
Mm,
It remains, the learning counsel for the petitioner is worried about the maintenance, the quality of maintenance done
okay.
there. And then see it's a thin layer. It won't last, it's not lasting even, of course. So how these, whether these people, the contractor, will be in the vigilance enough to look after all this? Or where do the people complain if the people are aggrieved?
Sir, whatever maintenance operations we have undertaken, this is not as per the NS standard.
Okay.
It's just for maintenance.
Oh.
So when the original contractor comes, they have to scrape up and relay and reconstruct up to the NS standards.
Okay.
That's it. Just it's only for this one. In between repair maintenance only. It's been done. The ministry has given the provisions. So take up the STMC after the termination and in between the period. Like, understand?
See, we don't draw pleasure calling you again and again. And it's a public interest, as you know, and people are suffering. Somewhere it has to be given quietus. You do your job and let others to do their job equally. Let us not disturb each other.
Sir.
What can we do? We'll wait for some time.
Yes, my lord.
Let us see.
As far as, my lord,
We'll record
what
the-
I am praying, my lord,
Yes.
there is already a direction that as far main part is concerned, let them get on with it as fast as possible. As far as this petrol is concerned, I have understood now. Nothing is going to come out of it. It's a public money wasted. It's only around 5 crores.
We'll see, we'll see.
5 crores, but how is it possible?
5 crore is a
5
big,
crores
big
from
enough.
Itanagar to Chandan Nagar to
It's a
Nirjuli.
big enough. Big money.
Not for carpeting and carpet. I'm using the normal layman's word. Carpeting, is it possible? Absolutely not. So maintenance will be patched up here and there. Nothing is going to come out of it. We have understood that now. Let there be a direction.
even
Let
if
them
it
get
is-
on with it.
No, even if it is for patch up, to fill the potholes, it's maintenance if it is done properly.
That
Isn't
is
it?
exactly the
Because
difficulty.
that
It is
main
exactly the
contractual
difficulty.
on the
Now, while
next,
the executive engineer, he said he's going to explain.
Hmm.
Of course, he will explain. He's the expert. But I also have eyes.
Hmm.
We go on this road, drive through this road. We have not seen any change. And if they are saying that this is the maintenance, I am not on the maintenance anymore, my lord.
maintenance, no issue.
Maintenance.
We'll
If
see.
nothing is happening, nothing will happen.
No, it will happen. It will happen. We're here. We're here. We're not here to.
My lord, this is, my lord, the PWD authority. They cannot absolve themselves of this.
Hmm.
We filed this writ petition, PIL, in the month of July 2024. It was supposed to be completed in 7th of December, my lord. There were around 9 or 11 pillars, half constructed pillars at that point of time. If it was not, my lord, we have brought it to your lordship's notice, they would have not woken up. They just cannot absolve themselves. It was their duty.
We'll see. Because basically, where
I read an interview of the chief engineer that day. He says it usually takes a period of around 8 months to have all these things completed. This is September now. 8 months goes past the next working season. We will have another next year saying all these things about rain. Then maybe next October, I don't know how many people will be there left or not.
sir, let us not go into all these interviews and all. Cannot take the judicial notice of it. It creates more problem than the solution.
My lord, this is the difficulty. Their affidavit, they are never particular. How much is the time expected to complete this new process?
See, it's
They never say this.
basically we're monitoring it.
Yeah.
You have brought the matter before us. We're
Exactly.
monitoring it for the interest of the public interest.
But the fact remains, my
Taking
lord.
into the consideration the interest of the public. Is basically we're monitoring it.
Yes, yes, my lord. If you are
So
not for your
we'll see.
lordship instance, what has now at least been done, even that would not have been done.
We'll see. We'll see. Hopefully, it is done.
Hopefully.
So I request you and the chief department and the government, let us give quit us this problem. It's your
We
job.
normal men, my lord, why you drive back?
Why we
difficulty
keep
we
on
face.
telling you that you,
Can't
you
imagine
do
a
your
pregnant
job?
woman that-
Okay. We'll record the status report
Yes,
and
whatever.
then
it is.
we'll fix it up after 3 weeks for the status report. So
Yes.
far as the maintenance is concerned. All right.
Madam, and on the main thing that approval and all, there's already a direction from this honorable court by the last order that the state authorities as well as the central authorities sit together, sort out what is the discrepancies. This direction was given because twice their proposal was sent back by the MRTS. This is causing another delay.
They have said by this affidavit, they have already modified one as they have submitted. Has been resubmitted by chief engineer on 14/8.
Yes.
14/8, they have
So
resubmitted.
there may be a direction from this honorable court as far as that also to follow it up, to have it done as fast as possible.
We have given last order also in that.
That is the difficulty.
Anyway, heard Mr. Deepang, learned counsel for the learned senior counsel assisted by Mr. Dillon, learned counsel for the petitioners, as well as Mr. N. Ratan, learned additional advocate general for the state, as well as Mr. Milo, R. Milo, learned standing counsel, highway, PWD highway. List of next para. In deference to the order of this court, dated 13/08/2026, comma, Mr. What's your name, please?
H. Tajang, huh?
H. Tajang, the executive engineer, Naharlagun
Nahalagan Highway Division.
Highway Division, PWD, is present. However, the chief engineer is not present on the ground that he is out of the station, for which an affidavit for the dispensing of his appearance is been filed. Is filed. Is filed. List of the respondent authorities, particularly the highway authorities, have filed the status report as directed by this court. Next para. The relevant paragraphs are reproduced here in under. Yes. Page 1013, huh? Affidavit. B, huh? B, C, D, E, F, G, H, G and H, huh? All you got it. Next para. Perusal of the status report reflects that the modified reversed balance cost estimate, along with additional works amounting to rupees 30,357.52 lakhs, have already been resubmitted by the chief engineer from a highway zone, PWD, Itanagar, to regional office, to the MOT on 14/08/2026 for review, and to forward the same for review and its expeditious approval. List of, as regards the the as regards the, what is maintenance?
Short-term maintenance contract.
TMC, huh? Short-term maintenance contract.
Execution of maintenance works to make the road in a motorable condition, the agreement has been entered into between the chief engineer Highway Zone, PWD, Arunachal Pradesh, on behalf of the MORT and Messrs. Akshaya Infra Projects Private Limited, Mumbai. List of, it is indicated that after the execution of the contract agreement on 05/08/2026, the contractor has already started the work for maintenance of the road in question. List of What is this? The list of we have considered the submissions of the council for the parties and also the executive engineer Naharlagun Highway Division list of the executive engineer Naharlagun Highway Division in his usual submissions once again assured this court that the works including the approval for approval of the new estimate as well as the execution of the maintenance will be taken up in a right earnest and the and the department would not left any stone unturned to complete the process as expeditiously as possible. List of having considered the status report and the submissions of the parties as well as the assurances and the article given by the authorities, highway authorities, particularly the executive engineer, Naharlagun Highway Division, we deem it appropriate to direct the authorities to expedite the process for approval of the estimate, modified estimate submitted by the responsible authority to the MOT. List of as directed earlier. Where was the direction? Which order? To sit with them.
Last order, 13/8/2026.
Huh?
13/8/2026, in paragraph 4.
What I said? What do you say? Last on 13/08/2026, this court once again reminded and directed the state authorities within bracket highway, PWD highway, and the MOT authorities to have a joint consultative meeting so as to finalize and approve the modified estimate. Have you done this or you have not?
Sir,
You have done.
sir.
Consultative meeting you have done. No.
No, meeting. We have to go to the RO office with the DPR. So there were 3 sittings already we had done. So again, we have to have a consultative meeting with the board.
No, then
we'll
not say the authorities. What I said last line. No, forget that. Direct the state authorities and the MOT authorities to expedite the process of approval of the modified estimated already submitted before the MOT, submitted to the MOT. Please stop. We also direct the authorities, particularly, no, direct the PWD authorities of PWD highway to properly monitor and get the works executed of maintenance work in terms of the contract agreement dated 05/06/08/2026. On the next date, the state PWIUA and the MOT cell filed a status report. Place the matter on.
My lord, the consultative meeting with the MOT may also be reflected, my lord, because now we have again sent it. Tomorrow again, if they have some objections, that's why this consultative meeting, along with the highest.
You have done or you have not done?
No, earlier we have already done that, but as per this direction, with the highest authority of the MOT.
We'll say within 10 days, another consultative meeting, because you have submitted.
There is no consultative meeting till that. No consultative meeting till that. It was only with regard to the regional office.
That will just, yes, you, there's directed on so and so, that one. We'll add that.
Yes, with the highest authority of the MOT.
Because it has not been done.
Yes,
Yet.
not done, not done.
Yes.
With the highest authority
We'll
of the
record
MOT.
that. Okay, you come later. We'll.
It's in paragraph 4 of the article. My lord, I may be disposed of dispensing with the personal appearance of the CE.
I heard Mr. Anderton, learned counsel for the learned additional advocacy for the applicant, and also heard Mr. Deepang, learned senior counsel for the respondents writ petitions. This is an application seeking dispense of the personal appearance of the Chief Engineer Highway, PWD, Arunachal Pradesh, as directed by this code on 13/08/2026. Next paragraph. The Chief Engineer Highway Zone, PW Arunachal Pradesh, was directed to appear along with the Executive Engineer, Naharlagun Highway Division, today. Mr. Howard, due to pre-scheduled official engagement, it is informed that however, it is informed that the Chief Engineer so-and-so could not appear before this court due to pre-scheduled official engagement, for which he had to proceed to New Delhi. Please stop. In the absence of the please stop, huh? Therefore, 6 for dispensation of his appearance. Please stop. Next, having considered that the chief engineer, having considered that the in place of the chief engineer, superintendent engineer within bracket headquarters, IWAJ on PWD is present along with the executive engineer, Naharlagun Highway Division, we deem it appropriate to dispense the presence of dispense with the personal appearance of chief engineer, IWAJ on PWD, Arunachal Pradesh. Stuff. And as the status report, along with the actual status on the ground is being placed by both the officers present. This stuff. I instance disposed of. Just correct it.
Item number 5.
My lord has fixed it there.
After we'll list the matter after in earlier, in the writ petition in PL,
In the PI.
list the matter when
September. Can it be 15th? 15th September.
15 September. So we'll dispense with their appearance.
Yes, I am not
We'll
on
see.
that. I'm not-
We'll see.
Yes,
For a timing where dispensing your
this is the,
personal appearance of this SE so and so, same, and the executive engineer are dispensed with for a timing.
yes. This is the only place where
Ah.
even after so-called maintenance, the roads feel exactly the same. This might be some sort of magic.
Last time, as I said,
This is
as I
unbelievable.
suggested, why not have a tour on Saturday?
I'm going to do exactly that to even
From
right now.
here, you come along with us. Isn't it?
We will also show the locations where frequent mudslides comes.
And the with the lunch by the not by the government, by individually by
Obviously, sir.
executive engineer, we invite all the lawyers, members of the bar.
My lord, let it be fixed on 15th September.
15 September, yes.
Problem.
Item number 5.
Yeah, my lord. My lord, I'm appearing on behalf of Chorpok Modi, my lord, council
Yes.
body petitioner, my lord.
Hmm.
My lord, respondents are yet to file their reply, my lord.
Yes.
My lord, we have already filed affidavit in opposition. But however, my lord, as per order dated, my lord, 9/6/26, my lord,
Hmm.
this honor court observed that the photographs which are annexed in our affidavit opposition, that is not visible. So in that regard, I was directed to take instruction from the authority.
Hmm.
So I forwarded the order, but however, my lord, instruction is yet to receive, my lord.
So what do you want to do? You tell us what you want to do.
My lord, instruction, because if authority instructed me to file the praise, then I will file praise. So instruction is
It's
still.
between you and the authority, not between us.
I may pray for 2 weeks' time, my lord.
Obtain instruction.
My lord.
Heard, Mr.
NUV, my lord.
And you be learned counsel for the learned counsel appearing on behalf of Mr.
Chorpok
C.
Modi.
Modi, learned counsel for the petitioner, as prayed for by Mr. L. Kurdu, learned standing counsel,
My lord.
IMC. Further, 3 weeks time is granted to obtain instruction as directed by this court earlier.
Authorized.
Right.
Item number 6.
Your Lordship, service is still awaited, Your Lordship. So I may be allowed to take fresh step. Your
List
Lordship.
after 4 weeks.
Much obligation.
Item number 7.
7 and 8.
My lord,
7, 8,
This-
9.
yes, 7, 8, and this is specifically fixed for hearing on suspension, my lord. of the
7,
convict.
8, 9, 10.
Other is not.
The ID card or the answer notes in the expression. You are appearing.
Yes.
Sole respondent.
My lord.
Yes.
Are Mr. T. Tagumlan counsel for the appellant. Although office note dated 17/08/2026. Indicates that neither the ID card nor answer notice in respect of sole respondent has been received by MS
P. Moyong.
P. Moyo, London Council, enters appearance on behalf of the sole respondent. According service is complete. As spread for by MS Moyo, 3 weeks time is granted to file appropriate affidavit. What affidavit is required?
Wakalat nama. They're yet to file wakalat.
To file 2 weeks, 1 week time is granted to file her power.
Item number 14.
Service completed. This I may be kindly fixed on 3rd September for hearing.
Served through the learned edition. Yes. In that
Your,
case, what-
Your Lordship, I'm filing wakalat nama for the respondent number 2.
What respondent number?
Respondent number 2.
Okay.
Okay.
Okay. Heard, Mr.
Omodi.
Huh?
Omodi.
Omodi, learned counsel for the appellant, as well as MS El Hage, learned additional PP for the state. Mr.
Artamin.
Hmm?
Artamin.
Artami, learned counsel, enters appearance on behalf of
Lordship, if possible, it may be
respondent number 2.
Lordship, it may be listed after 15, Lordship. On or 3rd, I won't be available, Lordship.
List the matter.
My lord, on 20 August.
20
On 20.
Sunday.
Huh?
20 Sunday. 21, 22.
When?
But,
September?
yes, September 3. I am praying for September 3.
22 September, Lordship.
22 September.
Lordship.
Hmm.
Lordship.
The record is there.
Item number 15.
Record is there. Yes, record is there.
Original paperwork.
Record is,
Paper book may be prepared, Lordship.
Then paperwork.
and then in that, not before that, huh? We will not fix it now. You just delete that, list it on 22. Last line, that sentence you delete that. Paper book is, record is received. Registered to prepare the paper book.
My lord,
List the matter after preparation of paper book.
my lord, can I say
We'll
IA?
see. We'll see.
My lordship, this is a criminal appeal jail. Lordship, this is a criminal appeal jail, lordship. I have filed a memo of appeal and IA, lordship, for condemnation of delay of 1,703 days.
Objection.
No, Your Lordship. Since
IA is for
Condemnation of delay.
it's a jail appeal.
This is for condonation of delay.
Yes,
Hmm.
lordship.
Okay. Mr.
Ji, lordship.
Legal aid counsel for the applicant.
1,700.
Also had Ms. Cheney, learned additional people for the state staff. by filing this application under Section 5 of the Limitation Act 1963. The applicant is seeking condonation of delay of 1703 days in filing the connected appeal against a judgment and this criminal appeal.
Yes, Lordship.
Okay.
Jail appeal,
Judgment
Lordship.
dated 23/12/2021. Sentence, where are you?
Sentence for Lordship life imprisonment, Lordship.
Okay. Passed by the Session Judge Consa, sentencing the appellant to undergo life imprisonment for the offense under Section 364A of Indian Penal Code, and to pay fine of Indian Penal Code, and to pay fine of rupees 20,000, and for the sentence to undergo rigorous imprisonment for 7 years for offense under Section 365 of IPC, and to pay fine of rupees 10,000. Is there any default clause also?
Sorry, my lord.
Failure to pay fine, is there any default clause? Okay. Stop.
Yes.
Default is
Default is there for 3 months, Your Lordship.
3 months with default clause, huh? Okay. Stop. The ground for, so since this is jail appeal.
Yes,
Okay,
Lordship.
jail appeal, come, the line additional PP, public prosecutor, has no objection condoning the delay in preferring the appeal. Stop. Huh? We have also seen the ground for ground cited for delay in preferring the appeal, and upon perusal, we are satisfied that the appellant has, the appellant being in the jail has a sufficient cause for not preferring the appeal within the limitation, within the stipulated time. Stop. In view of the delay in preferring the connected, a delay of 1703 days in preferring the connected appeal is condoned. Stop. With the above this highest stance allowed and disposed of. Okay. Then list the appeal. At least the connected appeal after a week or two.
Lordship, after paper.
Your Lordship may take up the criminal appeal in this case and further direct for the calling of the TCR, Your Lordship.
So, where has it been also listed? Where is the appeal?
Oh, yes. Your Lordship then may fix this matter after a week.
Hmm?
Main
In the appeal then, okay. Some order was already passed. The court has already called for in the appeal.
Yes, Lordship, I have also received TCR, but paperwork I have not received.
Okay, but
TCR,
the court probably has not.
TCR, I have received TCR. After that only I filed.
Okay.
How will you receive the
Hard,
TCR?
Mr.
The TCR is to be received by the court. No?
This is the same.
Where's
21.
the record.
The record,
Huh?
it's not available.
Otherwise called for only on
This year,
29/8.
19.
Okay. Hard, Mr. In appeal, huh? Hard, Mr. Legal aid counsel, huh? For the appellant. Also hard, Mr. P. Gini. Learned additional PP for the state staff, huh? The record calls for the trial court record as called for has not yet received.
No.
Hmm?
It's here. Already received, but
Already
in the
received.
connected criminal appeal 19, it is tagged with that.
Okay. Already received.
So we may list it along with the
Along with-
criminal appeal 19.
That can be done, Your Lordship.
Okay.
Then we'll pass the order for the
Okay.
preparation.
The connected appeal has already been called, huh? For in the trial court record has already been called in the connected appeal number
19.
19.
19 of 2020.
Stop list appeal along with the appeal number, huh?
19 of 2020.
19 of 2026. Oh,
Item number 16.
same, I think. Same.
My lord, this is an application praying for condoning for delay of 401 days in filing writ appeal against the order dated
Issue notice, huh?
0506/2020.
Okay, hard, Mr. T. Tago.
We'll have to issue notice.
My lord.
Land counsel for the applicant. This is an application filed under section 5 of the Limitation Act seeking condonation of delay of 401 days in filing the connected appeal against the order dated 5/6/2025 passed in WPC number 622/2023. Staff, huh? Issue notice. Returnable by 4 weeks. Staff, huh? The petitioner, the applicant shall take steps for service of notice upon the respondent by speed post as well as by usual process within a week from today. Release the matter after 4 weeks.
My lord, up to 18, my lord, the same, only case number is different. One is, next is 17, WPC number
16, 17, and 18.
6. Yes.
Similar order.
Similar.
Yes.
My lordship, I beg to mention item number 6, 7, and 8.
Why?
This matter may be listed tomorrow, my lordship.
Why? Affidavit has been filed.
Yes, my lordship.
Why tomorrow?
Today we have some difficulties. We have some difficulties today.
Why not today?
Maybe listed tomorrow, my lordship, for admission only.
Okay. In the prayer of MS K. Wang Lanut, State Council, and the prayer not being objected to by Mr. D. Soke, Learned Council, the petitioner, let these matters be listed. Tomorrow.
Tomorrow,
Tomorrow.
there's some urgency.
20?
Tomorrow, 19.
19.
Okay. 19? 0820.
Oblate.
My lord, I beg to mention item number 5, my lord, I may be granted 3 weeks time to file counter affidavit.
No objection.
No.
The prayer of Mr. T. Tagop Lanut, Standing Council Education Department, further 3 weeks time is granted to file affidavit of office.
Deeply obliged.
MS
NIO.
N.
IO.
IO Learned Council. So the petitioner is present.
Item number 1.
Yes, my lordship. Your lordship, kindly come to the
Page number 16, Annex 3. This is the memorandum submitted by the Nyapin-Pasang Student Union before the Commissioner Education. And on basis of this memorandum, Your Honor, the so-called notice was issued.
16.
Yes, page
copy
16.
is-
Type copy is in page 17.
Illegal appointment.
Yes, Lordship.
His own son, Sri Pani Karsang, BTech graduate.
Yes, yes,
post of general officer. 5 point something on the Okay,
Yes, Lordship. Now,
done so. Have you done so? Have you appointed your own son?
yes, Lordship, that is on basis of, on the recommendation of the school management committee for time being only.
If it's wrongly or rightly, it may
Yes,
be
sir.
right.
Yes,
But then they are contemplating to initiate proceedings against you. So there's no bar.
yes, Lordship.
You may found to be innocent also, and legally you have done also. But then they have decided to have an inquiry. So
Yes, Lordship.
pending inquiry and proceedings, you have been suspended. What's wrong?
No, my only ground is, Your Lordship, only the violation of natural justice.
But natural, no.
You know, without,
It is not required.
Lordship, without following the,
Suspension is not required.
without following the order altum patram, Your Honor.
No, that will be after that only.
Lordship, the petitioner was
Now it will
neither
be given.
given an opportunity to be heard, Your Lordship.
There's no requirement under the law that before suspension.
Suspension is there, Lordship.
Before suspension, no requirement of hearing. All right. Wrongly or rightly, there's an allegation
Yes,
against you. They have decided to go for this. Either you withdraw and no notice is required. There's no other ground. Only your ground is
Natural justice.
violation of
Natural justice, Your Honor.
no. It is not required. That's not the law. I'm sorry. Is it so? Is it not?
Only my submission is notice may be issued to the respondent, Your Honor.
Cannot be. It will give a
Yes, sir.
wrong message. Because when your only ground is no, opportunity of hearing.
Yes, Lordship.
If it is not the law,
Yes.
we cannot. Either you withdraw it or will dismiss the writ. No notice.
So we do live to file the same in future.
It's always there.
Yes, Lordship.
Because today you are coming only on the ground of principle of natural justice,
Yes.
which is not required. Now, in future, if you have a suspension, if you have something like the most common ground is
Certain technical issues there.
if a suspension is not reviewed within 90 days,
Yes, sir.
then you may come. So there cannot be a bar or kind of this thing.
Yes, yes.
What do you call it? Estoppel or something.
Malad.
Your Lordship, in fact,
Even not your the what do you call it? Liberty is not required. You'll not be debarred.
Your
On
Lordship,
some other ground.
yes, Lordship, my submission that regarding this appointment, that is in the knowledge of the DDSC, and in
It's
fact,
okay.
yes,
You
Lord.
put all the thing when the notice is given to you.
Yes, sir.
Isn't it?
During the departmental proceeding.
When inquiry is done, before that, obviously, when it is initiated without giving a notice, then you may come back. Suspension, we cannot.
Your Lordship, so-cause notice, we have replied the so-cause notice. We have replied the so-cause notice, yes.
That has been given in that case.
Yes, Lordship.
Even it is not required, but then you have been given. Withdraw or dismiss on merit.
Withdraw the petition.
Okay. Heard Mr.
P. Bate.
P. Bate, learned counsel for the petitioner. Not heard, huh? Mr. P. Bate, learned counsel for petitioner. That arguing the method. at some length fairly submits that he may be allowed to withdraw this writ petition in view of the fact that the suspension order dated suspension order
Suspension order dated, let's see.
6/8/26.
passed by the Commissioner within Bracket Education, Government of Arunachal Pradesh has been put to challenge on the ground of violation of principle of natural justice, which in fact is not the requirement under the law. At the same time, a notice, although notice was issued, which the petitioner had replied, Mr. T. Thagulan counsel for the petition. Thagulan standing counsel for the response. The decision depend for respondents. Really, desperate for no, the prayer of the petitioner for withdrawal is accepted. Accordingly, writ petitions closed on withdrawal. Closed on withdrawal. Not happy. Unhappy.
Your Honor, if lordship is possible, maybe dismiss on merit. Otherwise,
Okay. Then hard so and so, huh? Both, huh? Considering the issue raised in writ petition and the ground of challenging the suspension order of the petition. Come on. This writ petition is disposed of at the motion stage without issuing common notice to the respondents, as the ground sought for, as the ground for challenge is only on non-issuance of notice to the petitioner. List of next para. The petitioner is serving as
vice principal.
vice principal in the vice principal at Government Higher Secondary School in Kurumkume district.
Yes, yes.
Karadadi.
No, Kurumkume district.
Kurumkume district, Arunachal Pradesh. The Kurumkume district, Arunachal Pradesh, while serving as principal, a vice principal in the said district.
Principal in charge.
Principal in charge, huh?
Yes.
In charge.
Yes,
in
yes.
charge.
Principal in charge. Vice principal or principal in charge?
His principal in charge now, well,
While serving as principal in the said school, due to having found that due to shortage of science subject for the academic session 2025-26, and due to untimely demise of, on account of untimely demise of the incumbent science teacher, incumbent TGT science, science teacher, and considering the difficulty faced by the students, the School Management Development Committee has taken a resolution to appoint one Sri Pani Karsang, civil engineering on temporary basis. List of accordingly. The said Pani Karsang was appointed temporarily. List of next para. The genesis started on the memorandum submitted by the Nyapin Pasang Students Union on 15/06/2026 before the Commissioner Education within Education Government of Arunachal Pradesh, essentially seeking the transfer of the petitioner from the said government higher secondary school on various allegations. List of on receipt of the said memorandum by the Nyapin Pasang Student Union, the Commissioner within Education has issued a so-called notice on 17/06/2026 to the petitioner to appear in person and submit written reply before the head of the department on the allegation of appointing his son Sri Pani Karsang to the post of junior teacher within officiating against the vacancy of junior teacher. As the allegation of such appointment is considered improper and unbecoming of government servant. List of pursuant to the petitioner submitted his reply on 22/06/2026. Wherein he had attempted to clarify that due to shortage of science teacher and for the interest of the students, one Sri Pani Karsang was appointed temporarily. And also due to the descendant of landlord who has freely donated their ancestral land for establishment of the government school on the basis of the recommendation of the School Management Development Committee. on Mr. receipt of the reply and hearing the party and counsel for hearing the petitioner, the impugn order that is 07/06/2026 was issued, placing the petitioner under suspension, contemplating departmental proceedings. Mr. So-and-so, learned counsel for the petitioner, submits that the impugn suspension order has been issued in violation of principle of naturality in as much as before issuing the suspension order, no notice was issued. No hearing was, no opportunity for hearing was provided to the petitioner. Therefore, on this single ground, the impugn order of suspension that is so and so is not sustainable. Next paragraph. Mr. Titago, learned counsel, on the other submits that there is no law, it is not the law that before suspension of employee, a notice has to be given. As the suspension is done under the applicable CCA rules 1965, contemplating disciplinary proceedings. Therefore, there is no, therefore the order impugn and there is no infirmity in issuing the impugn order, suspending the petitioner pending departmental proceedings. Next, consider the submissions. The only one and only ground of challenge of the impugn order dated 07/08/2026 is to the effect of alleged violation of principle of natural justice on the ground no opportunity of hearing was provided to petitioner before passing the impugn order of suspension. Mr. As per Rule 10, within bracket 1, bracket close, CCS rules of the Central Civil Service, CCA rules 1965, Rule 10. Which is admittedly followed in the state of Arunachal Pradesh. The authority or the disciplinary authority empowered may place a government servant under suspension where a disciplinary proceeding against him is contemplated or pending. Mr. There's no requirement of issuing notice or hearing to the government servant before placing him under suspension, contemplating disciplinary proceedings. Mr. It is in the present case, although law doesn't require any opportunity or any requirement of hearing before placing the government servant under suspension pending departmental proceedings, on the records reveal that a notice, a so-called notice, was issued by the Commissioner within bracket Education bracket on 17/06/2026, directing to appear in person and submit written reply, to which the petitioner has complied with by appearing before the authority and filing and submitting the reply and appearing before the authority as directed. Mr. Assuming that a notice is required to be issued, although it is not the law as such, it is apparently noticed that a notice has already been issued on the allegations leveled against the petitioner, to which the petitioner has complied with. Therefore, in any manner, in any view of the matter, there is no question of violation of principle of this injustice or affording any affording an opportunity of hearing. Mr. That's the ground to challenge. The ground of challenge to the impugn order of suspension of the petitioner when the departmental proceedings can be said to be illegal in any manner. In many, as the respondent authorities have acted in accordance with the applicable rules and the law. Regulating the suspension and the departmental proceedings. In view of the above, this court finds no merit in this state petition as accordingly. Writ petition is dismissed.
Deeply obliged.
Much obliged.
Item number 2.
What is this?
Made resolution. My lord, here, my lord,
the petitioner was suspended by an authority, my lord, who did not have the approval from the competent authority. Now, my lord, there was a challenge made to that suspension order at page 66. My lord, here I'm challenging an subsequent action of the authorities while the matter was pending before this honorable court, and this honorable court directed the authorities to place instruction as to whether there was any approval or not. Now, to make the challenge redundant, my lord, they have taken a resolution whereby they have ratified the order of suspension, which was a subject matter of challenge in the writ petition. If your lordship will kindly see, page 66 is the suspension order. If my lord finds the suspension order for a moment, page 66. Now, my lord, this was issued by the respondent number 3, my lord, in the projecting that it was by the Board of Management. Now, my lord, we challenged before this honorable court, questioning the, my lord, the validity of this order. My lord. Lordship at page 68 on 24/7/2026 issued notice, my lord, and fixed the matter on 31/7. My lord finds page 68 is your lordship's order.
Yes.
Yes.
What is to be done today?
And thereafter, my lord, on 31/7, my lord will kindly see, my lord. Your lordship has very rightly observed.
Challenge the suspension order.
No, suspension order says challenge in a writ petition that is pending.
What is the order there?
My lord, in page 67, this, my lord, your lordships issued notice and sought for instruction from the authorities, my lord. Page 68, my lord. Page 68. If your lordship will kindly see paragraph number 3, my lord, will note. It is the case of the petitioner that the suspension order has been issued by an authority who is not competent in view of the fact that the appointing and disciplining authority is the Board of Management so-and-so. It is contended that so-and-so rules 1965, it is appointing authority or disciplinary authority that may place the employee under suspension contemplating disciplinary proceeding. Issue notice returnable 31/07. Now, my lord will kindly see on 31/07, it was fixed for consideration of the interim prayer. Now, my lord will kindly come to the next date order, my lord, page 70, 31/07. Page 71, order starts from page 71. Well, fourth paragraph, your lordship will see. Having considered the submission of the learned counsel for the petitioner to that effect that the director, respond number 3, hearing not the authority competent to pass the impugn order placing the petitioner under suspension, being not appointing a disciplinary authority by an order dated so-and-so, the respondents were put to notice to place on record whether any resolution or decision has been passed by the Board of Management authorizing the respondent number 3 to pass the impugn order, or whether any power has been delegated to the respondent number 3 in that regard. So-and-so appearing on behalf of the director Neres by placing a copy of the minutes of the meeting of the Board of Management submits that the Board of Management has approved the report regarding observation of the Academic and Administrative Committee and has also ratified and approved the suspension of the petitioner by its minutes dated 29/07/2026. So-and-so learned counsel has also placed the copy of the communication dated 27/5/2026 addressed to the chairman seeking approval to place the matter under the suspension. Perusal of the materials placed by him indicates that no decision resolution had been taken by the Board of Management appointing authority of the petitioner at the relevant time. Although the impugn order of the suspension has been issued by the director, who is admittedly not the appointing authority under the rules to place the petitioner under suspension, the boards has subsequently stated to have ratified the same, and the conduct of the respondent prima facie indicates that the same appears to have been taken to stultify the matter, which is in session of this court.
It was listed on 6. What?
Yes, my lord, thereafter they have filed the affidavit. My lord, it was heard, but the order has not been passed. Now, my lord, what I'm challenging in this petition, my lord, is page 79, my lord. Only to the extent of the minutes, that ratification and approval, which is per se illegal, my lord.
80?
Page 79. Page 79. 79. Lordship will see 1.1 10.12 within bracket 1, my lord, finds to report the action taken on Ministry Education dated so and so 27/5/2026. As per the direction of the Ministry of Education.
Okay, heard,
My lord.
Mr.
My lord.
B. Kaushik, Learned Counsel for the petitioner. Challenge made in this state petition is to the resolution
Resolution.
dated
Resolution dated 29/07/2026.
29/7/20.
29/07/2026. Page 73, my lord, to find.
07/2026 by the Board of Management, NERIST, in its 110th meeting, particularly the resolution number 1.10
My lord.
point 12 within bracket 1 bracket close, whereby the
There are two parts in this resolution. I have challenged only one part.
Huh.
Second, my lord, in fact, I am asking a prayer in this petition, my lord,
No.
for conducting that inquiry.
Thereby the two member, what is this?
Resolution, my lord, first part is ratified and approved. This is only challenge, my lord.
Ratified
And approved.
and approved
The suspension.
suspension of the petitioner by the Director NERIST.
Well,
Director NERIST. Mr. That's all.
second part, I am not challenging. Second part, my lord, in fact, the board has independently taken a decision to constitute a two-member committee to examine the correctness of the report, which was the source of my suspension. My lord, that I am not challenging, because if that is done,
That's why I said,
yes.
that's all.
My lord, I am praying for a interim stay, my lord.
Interim.
My lord, because per se, my lord, this order ratification is illegal. My lord, I am relying on the judgment. My lord, in fact, what your lordship has observed on 3107, my lord, that's the proposition of law.
So we'll issue notice list along with that judgment and that writ petition.
My lord, since
Otherwise, it will, it will become clumsy.
no, my lord, the suspension independently has to be.
You want to remove the foundations.
No, that is not the foundation. That is a foundation being
What
created.
this is ratified, if you say so, could have ratified, they have the authority to ratify the action taken, then your suspension cannot be the suspension cannot be considered.
There's no.
Therefore, we'll issue notice to we'll fix the matter along with that writ petition, which challenges the suspension order.
It's fixed on. It's fixed on 28, Lordship.
20.
20.
What I'm challenging here.
We'll consider on that. Issue notice returnable by 28. We'll say 28.
28.
28/08/2026. As all of you are appearing, all.
Kasi ang 1 and 2 list. 1 gabos. Yeah, pang.
Huh?
I'll be for Director 3.
As Mr. K. Mena, Learned Counsel, appearing on behalf of the Senior Counsel A. Apang for respondent number 1 and 2. And Mr. J. Jini for respondent number 3. Enters appearance and accept notice on behalf of all. There is no formal notice in it. Bishop Swain. At least the entry prayer of the petition shall be considered on the next returnable date. List along with WPC
339.
339.
339/2026.
of 2026. Otherwise, it will get clumsy or it will get diluted.
Well, what I'm actually basically my challenge in this repetition
And
is the defense which they are creating now.
what you cannot do, what you could not obtain, you are trying to obtain indirectly. You cannot. You are trying to obtain indirectly.
No, my lord. 31/7, your lordship's order is very clear, my lord. Your lordship.
Okay, I
yes.
understood.
Yes.
But then,
My lord, in fact, even if I would have not have challenged this, my lord,
consider that will
yes, that, my lord,
that they will fix for.
in fact, our division bench has decided in a similar matter, my lord, where it was being done in this manner. this honorable division bench said that no, this order will not come in a way because you did it because only for the purpose to make the challenge redundant.
See, once they have the authority to ratify, all right, conduct, we have noticed it.
Yes.
We've understood, but then if they have the authority to ratify the action by the authority who is not competent or whatever, authorized, I think something.
In fact, my lord, that is what
So you come up with
precisely
the affidavit.
Yes, precisely my argument would be
Anything on that.
my lord,
The
precisely
power to ratify.
yes, precisely my lord, my argument would be that although they have the power to ratify, whether they could have done it when the matter was subjudiced. My lord.
Okay.
That is subject matter of issue in this case.
Let's see.
Yeah.
Grateful, my lord.
All right.
Item number 3.
May I plead your lordship? Lordship, in the instant writ petition, I'm challenging the order of penalty. This is a third round of litigation. Lordship, it's a.
Well, issue notice.
Lordship, there is a.
Nothing else.
No, Lordship, what
What is the order?
Lordship, the order is.
Mister, what is the order?
Order is of page 110, 4425. Lordship, give just 5 minutes, Lordship. I want to. Lordship,
No, what do you want today? Will issue notice?
Lordship, because here what has happened is in the earlier 2 rounds of litigation, the
disciplinary action final order.
Yes,
I have seen that. It's a second history.
Yes, Lordship.
It's on second history.
Lordship may be.
This is 4th time or 5th time you are.
Third time.
Third time you are.
First time it was penalty was imposed. This
Consider
honorable.
everything, but today we'll issue notice. This.
Lordship may just.
What is the ultimate this thing?
Lordship, before coming, if Lordship is.
What is the ultimate order?
410.
Where is it?
It starts from 110.
No, where is the in this order? What is this final?
Oh, final.
Ultimate order. Ultimately, what you and reflects the serious nature of proven which can be imposed necessary to mention instances of disciplinary. What does it mean? Why
Final page 123.
What does it say? Finally, the inquiry company has been ignored. Based on evidence has been ignored in German sufficient reason like this, especially
Lordship may just
impose as a result, including the arrest for us. Dismissal from service with so and so, points of fraudulent.
Lordship may.
Yes.
Just 2 minutes. Lordship may come to page number. If Lordship
only
takes,
1 minute.
Lordship may take this list of dates just to.
Why?
Lordship
Then
can.
we'll issue notice. We'll call for the records and we'll see.
Lordship may come to just page number.
No, it's okay.
No, Lordship, the earlier round of I just want to
What
show.
do you want to say? What do you want?
The earlier round of litigation.
What you want? We'll issue notice.
Yes, Lordship, but I'm paying for an interim order. Why?
What interim order?
Because the provisional pension was being paid to me. That has been stopped.
No, once this is dismissed, it's
No, Lordship, that's what because it was illegal, prima facie illegal, because the high learned single judge said that the writ petition, the departmental proceeding can proceed only if it is permissible under rules. And the rules are here where after one is retired, it cannot proceed. That is my submission. That only that two paragraphs of two judgments.
That is a gray area. We'll determine.
But two paragraphs.
We'll determine that. I'm not sure. Since I'm not sure, therefore.
Lordship may just peruse the rules.
Consider on that day.
No, Lordship, because here if the provisional pension.
See, this court is very liberal in granting interim order.
Lordship, because that's if Lordship allows me to.
Don't force me to reject your.
No, I'm not
keeping it open because we have to see. Ultimately, wrongly, rightly, order has been passed. Dismissal. Why now? Maybe
yes, Lord. That's now wrongly. That
it's not without hearing them. We cannot. On next date, we'll consider your interim.
Then a short date may be given for.
From where it will come? From where? Nahalagan.
Lordship.
Nahalagan.
I think the council is already appealing.
No, I'm appearing on behalf of standing council.
Standing council is for the respondents only.
Yes.
Mr.
Ajay Das.
Ajay Das, London Council for the petitioner. challenge made in this writ petition is to the order that is 0404
25.
2025. After 4 months.
No, Lordship, it's after 1 year, but
04,
because
04,
I've annexed the medical certificate.
0404 2025 passed by the
Respondent number.
Tell the name, please. The chairman cum disciplinary authority, Arunachal Pradesh Rural Bank, head office, Naharlagan, whereby the penalty imposed earlier has been reaffirmed. Has been upheld, has been reaffirmed by dismissing from service with effect 02/06/2018. No, internally, huh? Well, no. With a fines on fraudulent amounts, suspension period, classifying the suspension period as not on duty, holding no entitlement to areas of salary revisions, etc. List of it is the submission of learned counsel for the. It is the case of the petitioner that the this matter the petitioner has filed this writ petition and this this is the third writ petition filed by the petitioner against the disciplinary proceedings and the consequential dismissal from service and the penalty imposed, penalty of dismissal from service. List of it is contended that the in the earlier round of litigation, this court has directed the respondent authorities to initiate proceeding. What?
The earlier round, the earlier orders were quashed. And in the earlier round, it was specifically said if the respondent's authority want to proceed, it has to be as per law.
Whereby the impute order of dismissal, the order of dismissal from service was set aside, however, with an observation that if the
respondent wants to proceed with the department proceeding, it will be as per law.
Wants to proceed with the further proceedings. So with the further wants to proceed with further proceedings, same shall be in accordance with law. However, the impute order has been issued mechanically and in violation of the
regulations
and law. List of issue notice returnable by 4 weeks, 3 weeks, 3 weeks. As MS, you are appearing for all.
Yes, Your
MS.
Lordship, Valika Jaina.
Huh?
Valika Jaina. W. Jaina.
Counsel appearing on behalf of
Teto Taba.
Mr. Tito.
Standing counsel.
London Council. London Standing Council. Arunachal Pradesh Rural Bank enters appearance next notice on all the respondent. No problem notice will be served. However, except of is furnished to the London Council. Respondents. London Council appearing on behalf of the respondents. Call for the reports.
One small prayer.
Interim prayer of the producer. Interim prayer shall be considered on the next date.
And Lordship, one small prayer. Inadvertently, I had missed to file an important document that may be allowed.
File an additional.
Look, may I just take a liberty, my lord? Item number 9. My lord, here, my lord, I'm
Item number 4.
What is this? Which for the petitioner?
Your Lordship, Mr. Bui, Putobu. As it is, Your Lordship, this matter has become infractious.
Ah,
Yes, Your Lordship.
how?
Because they have put to challenge 2025 notifications, election notifications. The tenure has already been,
Conducted.
yes.
Election has already been.
Fresh election was already conducted for fresh tenure.
None appears for the petitioner on call. When is the press election?
No, that has not been annexed. They have put to challenge 2025 notification.
Where it is?
Your Lordship will find at page number 34, Your Lordship. Sorry, Your Lordship, 30, page number 30. Annexure C. Jila Parishad Chairperson elections. They have put to challenge this notification. As well as the speaking order passed by Deputy Commissioner in page number 34. Yeah.
Vacant seat of Jila Parishad chairperson.
Yes, Your Lordship.
How it was vacant?
After bifurcations of new district, Your Lordship.
Okay.
From Lords 1-3 to Kipanyo.
So this is
Last election.
Last election.
Yes, Your Lordship.
And when was this election? They present there.
That December 2025.
Is it?
Panchayat election, Your Lordship.
Okay. Miss MS K1 Mulan, State Council, and Miss MS.
I'm for respondent number 1.
And then MS and Anju, then Standing Council.
Yes, Your Lordship. State Election
Commission and MSK Mulan State Council are present. Challenge wherein this petition is to the notification of election dated 28/03/2025 issued by the returning officer K.E. Panyan District of filling up the vacant post of Jila Parishad chairperson of K.E. Panyan District. It is submitted that the next Panchayat, the matter pertains to last Panchayat. The last tenure of the Panchayati Raj institutions and the subsequent election for the Jila Parishad institution has already been conducted in the month of December 2025. Therefore, the writ petition has become infructuous. Considering resistance closed as in process.
Obliged.
Your dear sir, when the matter was moved, you appeared for the petitioner.
Oh, yes, and someone.
Item number 9.
May please, Your Lordship. Well, here the official respondents have filed their counter affidavit and served upon me yesterday. And the private respondent has also filed their affidavit on 14/8. I may be allowed 3 weeks time to file my rejoinder.
Mr.
And I'm appealing for the private respondent in this case.
Why?
Well, this is
You are
the case where at item 3, Your Lordship passed the order in the morning. Same person.
You are seriously contesting.
Well, I'm representing the first wife.
No, that's why you are seriously contesting.
She's complaining, my lord. She has not agreed, and under the custom, unless she agrees, and if Your Lordship goes to the conduct, Your Lordship will find very violent conduct. There are some photographs. I'm not going into all these things. But one legal issue is there. Initially, when the permission was taken to marry, that permission was granted by some authority in the nearest, but the CCS conduct rule says it has to be by the central government.
Because there is
an autonomous body, and they are under the control of the central government.
So it has to be central government.
Central government,
not by the state government.
No, that rule is clear. Rule itself says it is by the central government.
But then who has granted this?
Some authority from the nearest.
Okay. But that has been stayed. No, that is stayed by the division bench.
Division bench has said not to take any coercive action pursuant to that order.
Okay.
Since that order was passed without hearing me.
Okay. It is submitted by Mr. B. Kaushik, learned counsel for the petitioner, that and the affidavit in oppositions on behalf of the respondents have been served upon him yesterday, to which he would like to bring file affidavit in reply. Therefore, praise for 3 weeks time. This term, Mr. D. The learned senior counsel assisted by Mr. D.T. Mr. J. Siring, learned counsel for the respondent number 6, and Mr. J. Jine, MS NR,
3 weeks,
learned senior counsel for nearest, as well as Mr. J. Jine, for respondent number 3, director.
Single match too.
Respondent director.
Notary.
Director appears and are present. Prayer for adjournment. A prayer for 3 weeks time is granted. 3 weeks time is granted to Mr. B. Kaushik.
2 तारीख को बने 9 तारीख
3 weeks.
Any fix if Your Lordship fix date.
After 3 weeks.
9th.
Yes, 9. It's Wednesday.
Or
Highly obliged.
Item number 10.
May it please your lordship.
Yes.
Your lordship, perhaps my learned friend from the prosecution side is absent.
Huh?
My learned friend is absent, lordship, from the prosecution side.
So, when?
We can do it today, sir. Lordship, he was just here.
After some time.
Lordship.
Item number 11.
There is no signature of the respondent.
Yes,
Card.
Yes, my lordship. I have checked the report. Then
You take precise steps.
okay, my lordship.
Office note dated 17/08/2026 reflects that edited respect of respondent file is received, yet there is no signature of the recipient. List of in view above, Mr.
J. Modi.
GMO, the Learned Council for the petitioner. Press for it and is granted 2 days time to take persistent.
Okay, my lordship.
Five. Respondent 5.
Yes, my lordship.
Yes.
Published.
List after 4 weeks. List the matter after 4 weeks.
Also for matter item number 10.
Please, Your Lordship.
Yes.
Lordship, regarding my earlier submissions, Lordship, I have come out with some orders, Lordship, passed by a coordinate bench of His Honorable High Court, Lordship. If Your Lordship, maybe please, Lordship, I'd like to furnish a copy. Lordship, this is also a very similar matter, Lordship, successive bail application, Lordship, which was earlier rejected.
Out of similar matter.
Yes, very similar, Lordship.
Same FI.
Almost no, Lordship.
Then
Very similar, like according to the circumstances, Lordship. He was arrested on 2/8/2023, Lordship. And then the bail order was given on 31/3/2026, Lordship. Lordship, in this matter, I am praying for bail, Lordship. Under strict conditions, Lordship. I am ready to face trial, Lordship. And Lordship, moreover, the co-accused, he was a repeated offender, Lordship. I was not aware, Lordship. There are 2 accused in this case, Lordship.
This is for 15th. Page number 20.
Whether earlier in your case, whether you have taken this ground?
No, Lordship, no. No, Lordship. Earlier, it was taken by another council, Lordship.
No, it's not a question of another council or one same council.
Lordship, I'm
In
here.
that case, you have taken the ground.
No,
These
Lordship.
grounds were taken.
No, Lordship.
No, my lord.
No, Lordship.
My lord, this ground, whichever he has taken, this cannot be raised at this stage, as per the judgment rendered by the Honorable Apex Court in my lord, Sonam Raghuvanshi case, my lord. This is the technical objection, my lord. And here also, my lord, the observation made by the Honorable, our own bench, is on section 36, where is, my lord, it says, however, such failure by itself and in isolation does not automatically render the arrest void ab initio. And so far as, my lord, regarding the non-compliance of ground of arrest, that is the violation of constitutional mandate, my lord. In that case also, my lord, the Supreme Court has in clear term, my lord, explicitly, my lord, described the expect. When this expect issue has to be raised, it has to be raised at the very first instance, my lord. And once the matter has been disposed upon merit, my lord, then it attained its finality, then it cannot be, my lord, revived by or the later bail application, my lord. My lord, this is the judgment of the, my lord.
What is the status of the trial?
Lordship, it is fixed for evidence, Lordship.
No, how many witnesses, any witnesses? Have...
3 witnesses are there, Lordship. None of them is shown up, Lordship.
Huh?
3 witnesses are there in total. Independent witnesses, there are 3. None of them has showed up, Lordship. This is also cause prolonged incarceration.
None of them?
None of them has showed up till date, Lordship.
There no someone was issued.
My lord, the TCR is before, but we have not gone through the
Lordship
TCR.
may kindly peruse the TCR, Lordship, in this. And also, Lordship, the grounds of arrest will not furnish, Lordship. The family member of the accused were, Lordship, informed only after the production, Lordship, before the learned magistrate.
It's all bail application. When he was arrested?
Lordship, on 22/10/2025. Last year, October.
299 days, my lord.
You are permanent resident of?
Udalguri, Lordship. BTC. BTC, Lordship. Udalguri, BTC, Assam.
Within Assam?
Lordship. From the BTC area. Lordship, I'm ready to face trial, Lordship, once bail is granted. And moreover, Lordship, the grounds of arrest were also not. And Lordship, regarding my learned friend's submission regarding that judgment, Lordship, Supreme Court judgments are retrospective in nature, Lordship.
Yes, that will apply in your case, in that case. Retrospective.
What you were saying to say?
Sorry, prospective in nature, Lordship. My apologies.
No, no, it always have a retrospective effect.
Moreover, Lordship, even the division bench, one of this Honorable Gauhati High Court has, Lordship, given some opinion, Lordship. Perhaps your Lordship might want to check it once.
What opinion? Bail is
Regarding bail, Lordship, under the grounds of Section 36 BNSS.
No. This is third bail application.
Lordship?
Third bail application.
Lordship. Lordship, the second one was withdrawn, Lordship. The first one was rejected, but the page 39 is the second one, Lordship. Sorry, first one. First one was withdrawn and the second was rejected by this Honorable Court. There is an Annexure 6, Lordship, starting from page 34.
You filed bail application before the court.
Lordship?
Trial court you have filed?
No, Lordship.
Then you have withdrawn on the ground that you want to file approach the trial court.
No, Lordship, it was earlier a different counsel was engaged, Lordship.
Doesn't matter. What does it make a difference? Which is state is with liberty granted to produce while appraisable before the non-trial coefficient. See, repeated fixing of the matter for examination of witness, if nobody turns up, it could also be ground
Lordship.
for considering your bail by the trial court.
Lordship, I'm moreover, Lordship, I'm ready to appear trial, Lordship, on every date, Lordship.
It's not a question of trial.
Lordship.
It's a bail.
Lordship.
Why don't you apply?
Lordship.
When you yourself had taken the ground, liberty to file approach the court.
Lordship.
These grounds which you have taken now
Lordship.
should have been taken that time, at that point of time.
Yes.
Should have considered. Now on merit, we have already rejected your matter. So now, if for delay in trial and all that thing, best thing would be considered by the trial court only.
Lordship, this grounds were earlier not taken, Lordship. It was
That's why I'm saying earlier you could have taken it, then we could have considered at that point of time. Now it is fixed for evidence. Trial is going on.
Lordship.
It's a different thing altogether. These witnesses are not forthcoming and they are not showing off. They are not appearing. That is different thing altogether. But that could be a ground to, release you on that ground so that and that could be best considered by trial court.
Lordship.
Because he knows. Because as per the record, only one order is there to issue summons, and one on the day fixed for examination of the SI, she was busy somewhere in the meeting, so that was adjourned. She was not examined, and 3 persons summons were issued once only. So these are the things. As you said that the witnesses are not
turned up, Lordship.
They have not turned up, so you can apprise on that ground also you can.
But Lordship, I am praying here, Lordship, under the constitutional ground.
That we have understood, I've seen it. That's the only ground you are coming to. This is what it's very difficult to consider at this stage.
Lordship, but Lordship, your Lordship's brother companion justices have also considered on similar.
Doesn't matter. It depends on case to case.
Lordship.
There's nothing like that earlier.
Lordship.
Okay, then we'll decide.
Lordship.
Heard Mr.
NJ Daimari.
NJ
Daimari,
learned counsel for the applicant, and also heard Mr. Tiet, an additional PP for the state. I'll pass the order.
Lordship.
My lord, may I allow to submit 2 judgments on this?
Why 2? Only 1.
My lord, both are different.
Why?
One is for ground of arrest, and other one is for, my lord, the section 37. Recently, there the accused was in custody for more than 1 year. Paragraph also. Paragraph.
Put it on top.
Okay, ma'am.
Addition PP.
Okay, ma'am.
Which paragraph?
Yes, okay, ma'am. Obliged, my lord. I will furnish the obliged.
Item number 12.
Suppose if we grant bail, what would be the condition?
If, my lord,
We
if,
cannot impose 1 lakh, which is trying to, seeking parity in that order.
my lord, but it will be, my lord, execution of bond. He don't need to, my lord, furnish the bail amount, my lord. He has to execute bond only, my lord. He don't need to deposit the amount. And local surety, my lord.
Is it so?
Yes, my lord.
And in the event of Lordship violating rules, Lordship, NBWS may be issued against me.
That is the difficulty.
If necessary, Lordship, I will submit 2 bonds, Lordship.
Where's the reports? Let's taken the report. The judgment.
Which? कौन सा? तुम पेराटी का बोला हम सबमिट किया था तो फिर this one okay ये तक
Yes, yes.
okay okay
It's here, it's here.
okay man.
Okay, bail bond.
Bail bond matter, not the case deposit matter.
Bail for bail bond also.
Yes, ma'am. That will,
What does he do?
Lordship, he is a farmer, Lordship. As per instructions.
matter the twin condition has to be
What?
36 and 37 because the commercial quantity is equal.
And moreover, Lordship, my single prayer is that, Lordship, there are two accused regarding that same FIR, Lordship. There are two accused, Lordship. One is Sangrang Narjari and the petitioner in which I am appearing is Lordship Samdan Brahmo, Lordship. The other co-accused Sangrang Narjari, Lordship, he has already been granted bail earlier, Lordship, he has been already caught in NDPS case, Lordship. Regarding and trial is going on, Lordship, even an appeal is filed before this Honorable Court, Lordship, which is also pending, Lordship. So he is a repeated offender, Lordship.
So he is still in custody.
Lordship, even the co-accused is in custody, Lordship.
So what are you trying to say?
Lordship, regarding that, Lordship, I have no idea about his, Lordship, the part he is doing, Lordship, regarding that illegal stuff, Lordship.
Consider what you have pleaded with this.
not done the
He has not been released on bail.
No, Lordship.
In this case.
No, Lordship. No one is released, Lordship.
No one is
Both
released.
are in custody, Lordship.
No.
Both are in custody, Lordship.
The other one, he has already withdrawn the bail with the liberty to approach the matter special court.
Same thing he has done.
My lord, recently, my lord, during the pendency.
He has done.
Yes.
Do it.
Lordship.
Better go there. If not, come back.
But Lordship, there will be another round of litigation again, Lordship.
Doesn't matter.
And
who will stop you?
Lordship has the power, Lordship. That is why I have Lordship. Lordship has the jurisdiction, Lordship. That is why I have approached your Lordships.
Are you schooling me?
No, Lordship.
Then
I'm just praying, Lordship. I'm praying before your Lordship, Lordship, for bail.
we are not conscious about our jurisdiction or what?
No.
Huh? Don't you know? Okay.
Obliged, man.
Up to you.
Item number 12.
May I please, Lordship?
Yes.
For 7 of the respondent, headache, and for the rest of the respondent, service still awaited.
So some of them have, some of the respondents, some ID cards for some of the respondents have been received.
Yes, Lordship. 7.
Okay.
7.
Heard. No, Mr.
M. Tasso.
M. Tasso, learned counsel by the petitioners and MS. K. Wang, learned counsel, state counsel are present. Next paragraph. Office note there is 1708/2026. Reflects that the card in respect of respondent numbers 5, 11, 13, 14, 16, 21, and 26 have been received back. However, in respect of respondent number 6, 7, 9, 10, 12, 15, 17, 18, 19, 20, 22, 23, and 25.
And yours, instead of sorted number 2 and 3 have filed their affidavit. For that, we will be filing
List the matter after 3 weeks. They filed the affidavit.
Yes, to respondent number 2 and 3. State respondent.
In the meantime, as prayed for, no, in the meantime, the petitioner may file affidavit in reply to the affidavit of filed by the state respondent.
Item number 13 and 14.
IA is for what?
May I please, Your Lordship, IA for the interim relief under section 9 subclause 2 B, D and E, my lord. Regarding come to the part by part, my lord. First of all, my lord, page number 61.
Listed for first time.
Yes, my lord.
Please you notice.
My lord, the thing is just I just briefly submitted something, my lord. Page number 61, my lord.
Can we pass the?
Yes, my lord.
Can we pass the order without hearing?
Without hearing of the other part, my lord. Okay, give opportunity, my lord. So that because it's necessary to other party.
Mr. M.
Yes.
N. Bagra, learned counsel for the applicant. This application is filed under section 9(1) bracket, 9 bracket, bracket close
2
Roman small 2 B bracket close D E of the Arbitration and Conciliation Act 1996. What do you call it? 4. Arbitration Conciliation Act. This for what? You are seeking what?
Yes, my lord. Seeking for, may I come to the prayer, my lord? Page number 19 to 20. First of all, my lord, they took the bank
What prayer is this? Section 9 application is for what?
for whatever they took the bank guarantee, some deposit, fixed deposit, your honor. You know, this general register of the this honorable court, my lord. Because during the
What do you want in this application? This is for what? Nature of the application.
nature
Section 9 application is for what?
for interim relief, my lord, regarding the bank guarantee as well as the note they appoint any third party to fresh tender as well as do the same like as me, your honor, in the petitioner. Because in our contract they already terminated 19/6/2026. So subsequently this termination comes during the pendency of this suit, my lord. So they took the already terminated. Subsequently, they took the bank personal guarantee. So these two, your agree for our side, my lord. On this, subsequently, I filed this I application regarding interim. Comes under section 9, clause 1, subclause 2, B, D, and E, my lord, regarding interim relief. First of all, bank guarantee, which they took on 8/7/2026. So may, if possible, my lord, after the agreed.
Seeking interim measure of protection.
Yes, my lord.
In respect of performance security.
Yes, my lord. Performance bank guarantee.
Bank guarantee,
Yes, my lord.
Performance guarantee. Performance security,
Hmm.
Comma, bank guarantee and bank guarantee, etc.
And my lord, after they took this bank guarantee, if possible, then it's deposit to this registry of for a fixed deposit, my lord.
We're issuing notice today.
Yes, my lord.
I'm seeking what is section 9 application is about.
Yes, my lord.
You could have said interim measure.
You know, I have some.
Is returnable by 4
Okay.
weeks. You are appearing
Yes, Lordship.
Sub the copy to the.
as MSY Gao, Land Counsel to the Land Counsel appearing on behalf of Mr. M. Katolan DAJ. I enters appearance except nothing on all the respondents.
All the respondent.
This after 4 weeks.
You know, if possible, if short date after 2 weeks.
3 weeks.
2 weeks, 2 weeks, my lord.
Can you?
3 weeks. 3 weeks.
Central government, they will not. It's of no use fixing.
Okay, well.
3 weeks. We'll give you fixed date. But ensure Do you appraise, you go back and appraise the learned DSGA?
Yes, Lord.
What is the order, what have,
Yes,
what
yes,
you
Lord.
going to do? Any day, do you make any correspondence with the central authorities?
Arunang, yes, Lordship.
You will have to do it. All right.
Yes, Lordship.
Simply appearing and
No, Lordship.
seeking for the,
I do appraise
not
the-
to, you'll have to, I mean.
Yes, Lordship.
My lord, if the main case, my lord, this is a pending, they took the 3 times to filing their reply. So
But Lordship,
both are
it was in the
pending.
case of arbitration petition.
Yes, my lord.
Lordship.
So
That's why in the arbitration petition, he can file an application for interim measure.
only
Yes,
interim measure,
and
this,
Lordship, for this,
Therefore, where it is issuing a notice. All
yes,
right.
Lordship.
Okay. In arbitration, in main petition, Mr. The M. Bagralan counsel for the petitioner. As spread for by MS so and so, Y Gau so and so, appearing so and so. List this matter after 3 weeks. In the meantime, respondents to file their affidavit
yes, my lord.
in opposition. Yes,
Okay,
next.
Lordship.
My lord, last request, my lord. If there is possible any fixed date, my lord, because they gave him some ultimatum, because main case already took the 3 times adjournment.
3rd September.
That is 3rd September. Okay, 3rd September. If there's any confusion.
Lordship, that
3rd September is not possible.
Yes,
Today is what?
Today is
Make it
20,
3 weeks.
3 weeks, okay.
9 September.
9th September.
9 September, okay.
Okay, Lordship.
Okay, my lordship. Much obliged.
Okay.
Item number 15.
May I, my lordship, our affidavit is ready, my lordship. So this
Thank you.
matter may be listed on 27th, my lordship.
Well, in fact, my lord, today, my lord, by order dated 3/7/2026, my lord. Today, my lord, is fixed for my lord consideration of the interim prayer, my lord.
Yes. What is the interim?
My lord, for staying the my lord, suspension order, my lord, it has been prolonging, my lord. My lord, basically, my lord,
This is first time.
yes, first time, my lord, for consideration of interim prayer, my lord.
Affidavit.
We'll file, my lordship, within 1 or 2 days.
My lord.
We'll consider on this.
My lord, Mr. Tapin will be Mr. Tapin informed me that, my lord, he will be appearing for the assembly, my lord. So he told me, my lord, that he will be filing affidavit by tomorrow, my lord. So my prayer that, my lord, the matter may be heard on, my lord, on Monday, my lord. At least, my lord.
Safer side, 27th, my lordship.
My lord,
Why
if
27?
they cannot, my lord,
Why 27?
If by chance swearing is not done on time.
So then make it 26. 26.
26.
26.
My lord.
Monday is 24.
My lord.
Monday is 24.
24,
Make
my
it
lord.
26. So that in case they have not don't file this week, you can file by.
My lord, otherwise, my lord, while I was appointed as a librarian, my lord, there was no recruitment rule, my lord. And my lord, library science, requirement of the library science was not necessary at the time.
We'll consider
My lord.
everything.
Okay.
And Mr. R.C. Kellan, senior counsel, assisted by Mr. L. Bablan, counsel for the petition. Next para, it is submitted by Mr. M.S.K. Wang Lan, standing counsel, Ellen State Council, that affidavit in opposition on behalf of
Two, my lord, 2 and 3, my lord.
respondent number 2 and 3 shall be filed within 2 days. Therefore, press for listing of the matter on 26/08/2026. Praise the Lord. List the matter. As agreed to the party, let this matter be listed on 26/08/2026.
My lord, for consideration of interim prayer in terms of order dated 3/7/2026, my lord.
The prayer for interim shall be considered on the next date fixed.
Oblate.